This is a response after comments were made to the Heroes of Cavite Cultural Association. Comments that used the Wikipedia description of the requirement and the jurist Palacios Rubio of 1512. These comments provided a childish, ignorant and crude perspective on the reality and scope of this legal institution. They feed on a clearly insufficient and very deficient description from Wikipedia, of which no study has been published. No serious or in-depth knowledge can be deduced from this supposed and pretentious encyclopedia. It has even been totally discredited by lower-level historians and researchers. We know that Wikipedia vaguely and incoherently documents texts that are simply nourished by voluntary contributions from individuals without reliable sources. And on many occasions they pull from false sources which are given by mere opinionated commentators without any accredited knowledge. The requirement of Palacios Rubio's was born as a result of intelligent debate and analysis on just war that took place at the request of King Ferdinand the Catholic, who appointed a commission of jurists and theologians as a result of the famous sermon of Montesinos on the island of Hispaniola in 1510. This gave rise to the laws of Burgos of 1512. According to the University of Oxford, in 1934, these laws were the precedent of the Universal Declaration of Human Rights. And the requirement was the phase prior to a declaration of war that had to be just. The requirement and the just title of war. The requirement consisted of a formal legal act of warning or notice prior to war, i.e., an ultimatum, that was introduced into the law of the Indies from 1512 as a result of the dissertations and thoughtful deliberations of theologians and jurists summoned by the regent king of Castile, Ferdinand the Catholic, when his daughter, Juana I of Castile was incapable of ruling in order to deal with the affairs of the Indies and the good treatment of the Indians. According to Rafael Sanchez Domingo, the requirement was a prerequisite for the declaration of war to be legitimate. With this in mind, the jurist Palacios Rubio, as a member of the Royal Council and a prestigious jurist, drew up a model for the requirement that was intended to serve as an ultimatum prior to acts of war, in order for armed action to be legitimately justified and thus control acts of war by the first conquerors of America. This matter was dealt with in depth rigor by the councillors of the Crown, as was the general custom, dealing with all the affairs of the Indies. Given that the discoveries opened the kingdom to many new or unforeseen realities. This requirement, formulated by Palacios Rubio, was made for the expedition of Pedro Arias Doivilla to Panama from 1513 to 1519. Palacios Rubio's, in his elaboration of the requirement, as an expert jurist knowledgeable about canon law, knew that he had to include in his text the necessary allusions to the legitimacy of pontifical law, since it was the role of the Church to evangelize pagan lands, a faculty that the popes had delegated to the kings of Castile in accordance with papal bulls, found mainly in Bull Inter Caetera of 1493. This had been done before with Portugal in Africa, since the essential justification for the conquest was to evangelize and brought legitimate cause to the expansion in the Americas. Nor did Palacios Rubio's forget about the previous papal bulls that had been formulated by the pontiffs to intervene in an armed way in the Crusades against the Muslims in the Holy Land. However, the text prepared by Palacios Rubio's was not generally applied in the lands of America and can be considered a doctrinal contribution to the debates between the councillors. In Castilian law and the legal system of the Indies in particular, it was always equipped with a hyper-legalistic and hyper-formalities system, with the premise that every act in the name of the kings had to be documented and attested, so much so that American historian Louis Hank, on page 6 in his work The Spanish Struggle for Justice in America, stated that Spaniards were so accustomed to certifying every action they took that notaries were as indispensable to their expeditions as friars and gunpowder. In this commission of royal advisers of 1511 and 1512, and later in the School of Salamanca, which was highly recognized for its studies of theology, law, in particular that of the people or international law, and economics, there was a zealous debate about what should be the necessary motives, the procedures for declaration and the sufficient causes to proceed with a just war. In other words, cases in which the action of war was lawful and justified. Such considerations, of course, had not been formulated until then by any empire, and it is then that the Spanish monarchs legally articulate the justifications for armed actions to avoid unjustified or arbitrary acts of force. As contained in the compilation of the laws of the Indies, where there exists a complete list of laws. Title 4 of Book 3 is dedicated to war, specifically in Law 9, Title IV of Book 3, it's established like this. We establish and command that the Indians of any province may not be confronted or warred upon in order to receive the Holy Catholic faith, or to give us obedience, or for any other purpose. As can already be concluded from reading this paragraph, it is clear that this prohibited the war of aggression, and an extraordinary philosophical doctrine was created in the school of Salamanca differentiating wars of aggression, which were illicit and exceptional, or in very specific cases just, from defensive wars, which were always lawful. According to the royal decree given in Valladolid by the King Carlos I on June 26, 1523, Law 9 of Title 4 of Book 3 states the following line: "And if they are aggressors, and initiate war with an armed hand against our vassals, populations, and pacified lands, they are to be made the necessary requirements once, twice, and 3 times, and as many others as may be convenient, until they are brought to peace, so that, if these precautions are not sufficient, they may be punished as they justly deserve, and no more. And we ordain that if it be necessary to wage open and formed war against them, the Council of the Indies should be first notified, with whatever cause and motive there may be, so that we may provide what is most convenient for the service of God our Lord." The requirement, considered in isolation, that is, without knowing its motivation, legal regulation and purpose for its application, the historical circumstances and the historical context in which it was formulated, has given rise to gross manipulations, especially by the authors who take the document out of context, but in view of what has been exposed in its study, even if it is brief, and the eloquence of the laws enacted by the Spanish monarchs on just war, we have no doubt of their purpose and intention. It is a perfectly regulated legal institution with the legal nature of an ultimatum, from Latin, ultimate, final demand, to prevent unjust acts of war or abuses in the use of arms for spurious or arbitrary interests of a group without legitimacy to do so, which is what the monarchs tried to avoid. We have no doubt that in military tactics, these actions could possibly be simulated, or a mere apparent statement was given as not to frustrate a military surprise attack. But in any case, the law of the Indies prohibited prior aggression from their own group who was going to be attacked. From the regulation of the requirement in the laws of the Indies and the royal decree cited above, we can summarize its characteristic elements. 1. The requirement was the formal act of declaring war, which is something that has been done since practically the beginning of time, with some exceptions, between fighting belligerent sides. 2. The requirement in the law of the Indies had to obey defensive actions prior to aggression against the vassals, populations, or pacified lands. Let us remember that the natives of the Indies were vassals on equal terms to the other kingdoms of the Spanish monarch, and therefore armed action to defend or protect their natives from aggression of other native settlers was just and legitimate. 3. Armed action had to be proportional to the aggression suffered, punished as they justly deserve and no more. 4. Armed action was never permissible to convert to the Catholic faith. In this regard, there is extensive legislation and documented historical facts of peaceful evangelization and, by soft methods, on which we have so many legal records from the monarchs, for example, evangelizing the lands of Tuzla in Nicaragua, Costa Rica, Panama, the Yucatan Peninsula, the west coast of the United States, etc. Also, there were permissions to missionaries to enter unexplored lands to spread the faith without any element of armed force to accompany them, either because they were not capable of providing additional armed support or because the religious orders, in general, did not want armed support. These religious orders often sought sincere and convinced religious conversion not imposed by armed force. 5. The purpose of the requirement was to avoid war and as a last resort after exhausting all necessary attempts, make requests once, twice, 3 times and as many others as are convenient. To this end, the laws themselves gave the negotiators the power to agree on justified agreements. In Valladolid on September 28, 1513, King Charles I of Spain stated the following according to Law 8, Title 4 of Book 3, "If any Indians are in revolt, then try to reduce and attract our services with gentleness and peace. If it is necessary, grant them any liberties and familiarities of all kinds, and tributes can be made,